For pronouncement of judgment, item 1.
In view of the above discussions, we have considered view that the impugned order dated for 21/4/22 passed in so and so would not call for any interference, and accordingly, the writ appeal is held to be devoid of any merit and dismissed.
Item number 2 and 3.
Please, Your Lordship.
The writ appeals have been allowed, and the appointment of the private respondent number 9 has been interfered with. But the appellant's provincialization would now be considered under the 2017 Act.
I'm deeply obliged.
Yes,
Okay.
next one.
Next.
Late bench. Adjournment request, if any, from item number 1 to 6. From item number 7 to 16.
May I be before, my lord, item number 12, my lord, I would like to adjourn, my lord, on behalf of counsel for the petitioner, my lord. Out of station, my lord.
Item number
12.
Why don't you circulate the adjournment slip in advance?
My lord, I was just informed, my lord. For some
Adjourn.
oblige, my lord. Any date, my lord, next week.
Yes,
from item number 17 to 30.
May it please your lordship, lordship, I beg to mention item number 22, lordship.
adjourn.
3 weeks may be granted.
Adjourn.
by levity. Oblige, your lordship.
May I please, Your Lordship, I beg to mention item number 24 with the consent of the petitioner counsel, my lord.
24.
My lord, for filing of affidavit, my lord, 2 weeks may be granted in this matter.
Don't you move adjournment slip in advance?
My lord, we've taken consent today only, my
So
lord.
what do you mean by consent? You should have,
My lord, will,
adjourn.
I'm obliged.
My lord, may I mention for the item number 21? Actually, the youngest counsel father suddenly has ailing father actually. The health father deteriorated here, so he couldn't turn up today. So if you kindly fix another date for the, although we have consent with the.
Adjourn.
Thank you.
Any other request?
May it please, Your Lordship. Well, Lord, last month, a matter concerning eco-sensitive zone of Kaziranga was kept sine die by our lordship because on the submission of the Forest Council, that the matter is pending in the Supreme Court. We checked up, but that is not the case, Your Lord. The Supreme Court has already disposed of the matter. The issue there was about the elevated corridors and regarding the mining in the Karbi Anglong Park. The Supreme Court says that those matters are over, we are closing it. So I want the listing of my case because
Not covered by this judgment.
my lord,
Whatever you filed this. not
no,
covered by the
my
judgment.
issue was not dealt in the Supreme Court.
Next,
Next, Lordship, can it be on Monday?
it's equal.
Obliged.
My lord, I'd like to mention for urgent listing of a case, my lord, urgency is there. My lord, my property purchased from a bank, my lord, already in 2023, my lord, through auction, and again, this is put on sale on 29th, my lord. And that is, we approved there in the DRT, but because of the leave of the presiding officer, my lord, he's on leave.
That doesn't mean leave of the presiding officer for the high court is open, so you can approach the high court.
My lord,
That
there
we
is
can't
no
do
other
that, sir.
alternative way, my lord.
So that is very clear. We can't entertain in such matters. Once you have already approached the DRT.
Not my lord, the
Application or whatever it is.
presiding officer is not there, my lord.
If not there, then what do you mean? Then you approach the High Court for that reason.
My lord,
Must be
otherwise,
some mechanism for that.
another third party entrance will be there, my lord. Auction is
Whatever
29th,
it
my
is,
lord.
sir. Once you have approached the DRT, we are not supposed.
We
to
have not
exercise
approached,
our-
my lord. We went
We
there,
have
but
not approached even.
yes, my lord.
That's enough. We are not going to. Okay, get it listed. We are not going to pass anywhere. That's very clear.
May it be
That's the
29th, my-
consistent view of this court. We are not going to enter into office.
no other relief, my lord. Otherwise.
Get it listed in the next week.
Yes, Lordship.
Obliged.
Um, let's say, 29th,
29.
May I please your lordship, I beg to mention for listing writ appeal number 5/2024.
why?
The petitioners are going to be retired. That's
That is a pending writ or fresh writ?
that's
Pending appeal or fresh appeal
a pending appeal.
next week?
Obliged.
Daily list for orders item 1.
Well, in person to the last order, that is 14/8/2024. Council has to file a affidavit.
May I please, Lordship, I pay for further 10 days time to file our affidavit.
We have already granted you enough time. In August, we have granted you time.
We've already filed 2 affidavit, Lordship, as per the last order.
August to November, what you were doing?
My lord, they have not provided, only 10 days time may be given. Lordship. 10 days.
Last opportunity of 10 days is granted to the council for the, we are for the
Respond number 3, Lordship.
missing of autonomous
Missing
concept.
Yes, Lordship.
The concept for the missing autonomous concept to file. Affidavit pursuant to the order passed by this court on 14/8/2024. Let's come to 10 days.
Thank you, Lordship.
Item 2.
Hey, please, Lord.
Notices have not been served.
My lord, neither Eddie Carter nor answer notice returned, my lord. But after taking step, my lord, respondent number 3 communicated with this honorable court, my lord. One letter is there, my lord.
What? What?
That letter written to the Secretary of Finance Department for taking necessary action. Nothing else, my lord.
Whether this notices have been served or not.
That the notice report is not available. My lord.
The notice issued to the respondent number 1, 2, and 4 are awaited since long.
Yes,
The learned concept for the petitioner may take such steps for service of notice upon the respondent number 1, 2, and 4 by registered post and AD within a period of 1 week on taking such steps that notices be issued to the respondent number 1 to 4, reasonable 4 weeks thereafter.
obliged.
Item 3.
May I please?
Notices issued to the respondent number 1 to 5 have not been served.
My lord, the order was passed in presence of respondent number 1, my lord. Page 15, my lord, relevant
Acha, it's a
portion,
concern.
my lord, paragraph 9.
Which is the order?
Order dated 1/3, my lord, 24. Relevant portion, my lord, this page 19, paragraph 9.
1/3/2023.
My lord, 1/3/24. 23.
Was the directions?
My lord, directions were there, my lord, earlier, my lord, community, my lord, Sarania community was issuing certificate, my lord, by virtue of the order of the state government, my lord. That order was withdrawn. My lord, thereafter, my lord, also, this court, my lord, observed that, directed that if the government want to issue caste certificate the due process may be followed. Now, my lord, without following due process, that is mean, my lord, provision under Article 243, my lord,
Just a minute.
number of my lord.
Just a minute, please hold down.
Well,
What is the direction you are complaining of that has not been complied with?
my lord, not. My lord, hundreds of my lord certificate being issued, my lord. I have NS, my lord, so many documents, my lord.
When issued?
My lord, there after the judgment passed
By whom?
by my lord, DM, my lord, of two district, and my lord, we served the copy to the DM, my lord, additional district magistrate also, and the secretary also, and the order was passed in presence of the secretary herself, my lord.
So what are the directions which have been violated? You just show us.
My lord, paragraph 9 is there.
9, read paragraph 9.
Yes. Here they got the notification dated 5/6/2023 by which the Commissioner and Secretary to the Government of Assam in WPTBC Department had provided that all the persons belonging to Saroniya Committee will be issued STP certificate under the sub-tribe Kachari. The Secretary to the Government of Assam, the Tribal Department has made a statement before the court that the said communication in meantime had been withdrawn and it will be effect under the any further the communication provided the Saroniya Kachari community will be issued STP certificate had been withdrawn. It was challenged, my lord, that was withdrawn. We are not required to adjudicate the matter further, but however, we provide that as the said communication was withdrawn during the course of the proceeding, the present repetition, and maybe because of certain question being put by the court to the department, we further clarified that if the government of Assam intend to issue, include Saroniya community within the scheduled tribe community, the proceeding in this writ petition shall not be a bar on the authority, provided that the authority follow the due procedure of law. So without, my lord, following due process of law,
Then challenge that is separate cause of action. How the contempt is maintainable, sir? Which order has been flouted? These are the observation of the learned single judge, of the division bench.
my lord, the respondent, my lord, to follow, my lord, due process of law.
If any certificate issued without following the due process of
My
law,
lord.
you can very well challenge it independently. How this contempt is maintainable?
My lord,
Tomorrow they'll come and say, "Okay, where is the direction? So what is the contempt then?
my lord, because my lord, this honorable
This
court,
can't be the contempt jurisdiction, sir. You show us that this was the direction and this has been violated, that's all. These are the observations.
but my lord, they're supposed to follow the procedure as by the directed.
Sir, yes, the court has observed that it has to be followed, the due procedure has to be followed.
My lord.
But if they have not followed, then it's a purely an independent question. Which you can very well agitate in the appropriate proceedings, not in the contempt proceedings, sir.
My lord, to challenge individual cases, my lord, that is, my lord, in thousands, my lord, certificates are being
Maybe it's
issued.
thousands or hundreds or lakhs. You can very well challenge that action, but how the contempt is maintainable, sir. We are not saying that you don't have any right to challenge them, but not in these contempt proceedings, sir. What is this of the direction given by this court has been willfully disobeyed? Where is the direction?
My lord, if they issue so many documents, my lord, we have to approach the scrutiny committee only.
Simply you have to, whatever the procedure is provided, you have to approach. How we can examine all those things in the contempt proceedings?
Not, I am not for examining my lord, but my lord, the secretary to show why they are issuing my lord.
That is, once you raise this plea in the appropriate proceedings, then he will show. But kindly consider the contempt jurisdiction. We are only concerned with that when there is any willful disobedience of the order passed by this court. Now show us that this order has been willfully disobeyed. This direction of the court has been disobeyed.
It is paragraph 9 only, my lord.
And this is not the, sorry.
Screenshot, sir, if they want to disobey the order.
Yes, sir.
My lord.
Now,
My lord, on the basis of this observation and direction, my lord, on paragraph 9, we file this one.
no, sir, we don't find it. We are not convinced. We are not convinced, sir.
That you lordship will.
No, withdraw it and avail appropriate remedy which is available to you under the law. We can give you that much of option.
Yeah, as you-
Want to, after attempting to argue the matter for quite some time, then contact the petitioner on instructions has submitted that he wants to withdraw this contempt petition, however seeks liberty from the petitioner to raise issue of issuance of illegal STP certificates to the members of Sarania Kachari community in appropriate proceedings. Dismissed with liberty as prayed for.
But
Item 4.
Yeah, please, lordship, my lord. As per office note, my lord, 2410.
125, yes, we are appealing for.
Yes, Lordship, I may give all the response.
All the respondents, yes, as per the office report, notice issued to the respondent number 125 has not been served till date, however, Mr. Chaudhary put an appearance on behalf of all the respondents, hence the service upon the respondents is treated as complete. 12 days delay.
Hear it on
The the IA is filed on behalf of the applicant with the prayer to condone the delay of 12 days in filing the connected appeal. Learned counsel appearing for the respondent has not seriously opposed the application, hence the IA is allowed the delay of 12 days in filing the connected appeal is condoned, registry is directed to register the connected appeal and this for admission after 3 weeks.
Obliged, my lord.
Item 5.
My lord, it's regarding regularization of a part-time law lecturer in University Law College. My lord, I am
Yes, my lord, I am preparing for respondent one, my lord. So, my lord, 2 weeks time may be given, my lord, to file our objection, my lord, regarding, my lord, the stay petition, my lord.
My lord, one contempt petition is pending, my lord. And it is in the list
Matter
today, my lord.
requires consideration, so for the.
Yes, my
You
lord.
may file your reply to this petition, but till then, this order has to be stayed.
My lord, I am relying on, my lord, the 2018 8 only, my lord.
But there are certain issues. They said it was not a regular post. Then the respondent number one is not having the requisite qualification
It is a
as
substantial,
provided,
my lord.
as provided by the UGC. But
My
the
lord,
other things which has to be taken into consideration.
yes, my lord, Learned Single has held that, my lord, it is a, my lord, not illegal, but irregular, my lord.
Comes upon for consideration of the IA number 2 with the pay to stay the effect and operation of the order dated 15/12/2022. Passed by the Learned Single Judge in writ petition number
5333 of 2015.
5333 of
15.
2015. Stop. Learned concept of the applicant has submitted that the appellant, that the respondent number was not appointed against a regular post and was appointed in place of one part-time lecturer who resigned from the services due to health reasons. It is also submitted that the respondent number was not, respondent number one was not meeting the, was not having the requisite qualification as provided by the UGC and its regulations. Is submitted that the Learned Single Judge has not taken into consideration these aspects in right perspective. And the right perspective and has ordered for regularization of the services of the respondent in illegal manner. Then it consider appearing for the respondent number one, there's some time to file
2 weeks, my lord.
counter to
Objection.
the IA, which stop time frame for is granted list after 4 weeks. In the meantime, till next date of hearing, the impugned effect and operation of the impugned order dated 15/12/2023 is stayed.
Most obliged.
Item 6.
That is a delay of 23 days, my lord. Fine, they feel that.
I'm not.
No, which one you are appealing for?
I'm for respondent, my lord, petition.
Respondent which?
Question number one, my lord, petition.
You are. All the responses. Okay, the matter comes upon for consideration of the application preferred on behalf of the applicant under section 5 of the limitation act with the failure to condone the delay of 20 days in filing the connected appeal. Stop, Learned consent, pending for the respondent is not
Appeal to
seriously oppose the application and the petition is allowed, the delay of 20 days is condoned. In filing the connected appeal is condoned, register is directed to register the connected appeal and listed for admission after 4 weeks.
Obliged, lordship.
Chamber में
Item 7.
Well, the I for consideration of delay, there is delay of 1 day.
Please from the other side.
Well, this has come for the first time. Similar against the common judgment.
That, confessional appointment.
No, not, this is a tender matter. Their lordship has
Notice, issue notice of the IA. Returnable 2 weeks, registered date.
Item 8.
8, 9, and 10, same order. Anybody is appearing in any of the matter?
Item
Item
8.
10,
8.
8,
Your lordship,
item 8,
8, my lord.
you are appealing for?
Respondent number 1, 2, 3.
How many respondents are there?
5 respondent.
5 respondents. Do we have any objection regarding delay control?
I'm filing objection. my lord.
Issue notice, 8 में करते हैं issue notice, let Mr. So put an appearance on behalf of the respondent number 1 and let notices be issued to the remaining respondents to register daily and dusty returnable 4 weeks. In the meantime, the consent of the respondent number 1 to 3 may file his objection if desired so. Nine and 10
nine is same with 7.
and 10,
10, I am not.
123 days. They have to issue notice.
Not 9.
10 में 9 में issue notice.
Lordship, notice.
10 also, we are issuing notices.
Yes, lordship, the delay is there 123 days. Justice service may be allowed, lordship.
Registered AD and dusty.
Lordship.
Both.
And the main case is coming up on 12th of December, lordship.
Returnable on 12th of December.
Lordship. Highly obliged, lordship.
For admission, item 11.
May I please, your lordship? Yes, my lordship, as per the Assam Panchayat Act, my lordship.
How this PIL is maintainable, first of all, you satisfy us.
My lordship,
From the reading itself, it appears that it is your purely a public interest, private interest.
no,
Yes, it is there. Read para number 2.
yes, my lordship. That is, my lordship, I have stated about myself.
Myself, this reflects that you have a private interest. This is enough to presume that you have a private interest.
My lordship.
In para number 3, have you mentioned that I'm finding this for the benefit of these people
My lordship.
and they are not able to approach this court? That is that.
My lord, in my submission, I have written, my lordship. My lord, in submission that I have stated to file.
You have,
Submission paragraph may be seen, my lordship.
sir, the rules specifically says in para number 3 of the petition, public interest petition, you have to mention all these things. That you are filing this PIL for benefit of whom?
Yes.
My lord, paragraph number 3, Roman 2, my lordship, I've stated, my lordship. Part 9 of the Constitution under Articles 243G and 243C establishes the framework for local governments ensuring citizens' right to participate in democratic governance at the local level. Panchayats as organs of local self-government rely on fair and equitable representation to function
Have
effectively.
you gone through these rules? Guwahati High Court, Public Interest Litigation Rules 2011. Have you gone through? Rule 10, A specific government in para number 3 of the writ petition, specifying the class of person for whose benefit the petition has been filed and how two such persons are incapable of accessing the court themselves. If you have any grievance, you raise your individually this, how this in PIL? PIL can't be for this. If you have any grievance regarding delimitation or whatever it may be, you have raised an independent challenge, not by way of PIL.
My lord, another PIL also in this matter is also pending, my lordship.
Whatever it may be, we'll deal with it whenever it comes. Certainly, this PIL is not maintainable. Particularly, you have disclosed everything that you are this functionary of a particular political party,
Yes, my lord.
then more or less it is your independent cause.
My lordship. My only grievance is that my lord, delimitation should be carried out by the delimitation
That
committee, my
apart
lordship.
from merits, we are not questioning the merits of the case.
My lord.
What we are saying regarding the maintainability of this PIL in these matters. When there are specific rules, we have to be, we have to abide by those rules. Finally, we are not preventing you from filing an independent challenge to that. Not in this PIL.
There are three, my lordship, I have stated about my locus standi to file the PIL. sir.
Locus standi, no doubt you have locus standi to challenge this, whatever the delimitation process.
Yes, sir.
Locus standi, the 3 doesn't say about this rule. 10D is not speaking about locus standi. They simply say a specific government in permanent petition specifying the class of persons for whose benefit the petition has been filed and how two such persons are incapable of accessing the court themselves. Where is that? For whose benefit you have filed this? Yes,
Yes, my lord, my lord, Roman 4, my will see my lordship, paragraph Roman 4.
yeah,
3 Roman 4, my lord. Public interest and expansive locus standi doctrine. The Honorable Supreme Court of India has progressively broadened the scope of locus standi in matters where public interest is at stake, especially through public interest litigation in cases like SP Gupta versus Union of India and Bandhu Mukta Morcha versus Union of India. The board allowed individuals to file petitions on behalf of public or for larger interests of society since delimitation impacts a broad
so which
spectrum of the
larger
public.
society, which larger section of the society? You can vary, these are the vague statement and nothing else. When the specific rules are there, withdraw it and file whatever independent challenge you can make an independent challenge to whatever the delimitation process is there.
Yes, my lord.
After attempting to argue matter for quite some time, when the counsel for the petitioner has submitted that the issue raised in this PIL petition regarding the delimitation process by the respondent. In which area you are challenging?
Hailagandi, my lord. Hailagandi
In
district.
district Halakandi. he may be allowed to. File appropriate proceedings in individual capacity before the appropriate forum. Dismiss with liberty as prayed for.
Highly obliged.
In fact, 8 cases are pending, identical cases are before the learned single judge.
Yeah, it's a big deal.
Highly obliged.
Item 13.
May I please allow?
You are for,
I'm for the appellant here.
who was respondent number?
Respondent number 1. My friend is appearing for respondent number 1.
No, no. You are respondent number, you were respondent number. So in writ petition number,
Petitioner, writ petition.
in writ petition, you were also included as a party.
No, I was the petitioner, my lord. I was the petitioner in writ petition.
In writ petition, he was
Here
the writ
repeated as
petitioner. here.
a respondent number 1, my lord, in writ petition.
No, this state of Assam represented by Commissioner Secretary, Director. Capital Finance, 7, 8, represented by number 9, what will happen? You are respondent number 9 in the writ petition.
Yes,
What
I
will
was
happen?
the, yes,
And you were represented through a council.
yes.
Now come to this page number 4 of the judgment.
Yes, 54 year old.
Internal page 4 of the judgment.
Yes.
Yes.
Madam, they have not served the copy of writ appeal.
Herein, your lordship, the issue, yes. Yes, 4 your lordship.
Second para, page number 4 of the impugned judgment.
In view of the above and as agreed by the learned counsel for the parties to the proceedings, the impugned order dated so and so stand interfered with.
So it's an order by agreement, sir. How can you challenge it? You have agreed before the learned single judge that do this. You have done this. How can you challenge this by way of appeal?
Yes, this
It's
is,
an agreed order.
this is reflected here in your lordship, but
This is reflected and this is there, sir.
yes, yes.
Then
But basically,
once a order passed by agreement of the council for the parties, how it can be challenged again? What's wrong in this order then?
but in fact, your lordship, in this case, your lordship, the writ petition,
Whether you agreed or not, whether you have agreed before the learned single judge or not,
but so far it's reflect that your lordship,
we are not concerned, sir. This is an agreed order and against which writ appeal cannot lie. And if there is no agreement, then you have another remedy to approach the learned single judge by way of filing a review that we have not agreed, he'll consider it and decide it.
but in fact, your lordship, we agreed. Yes, I understood your lordship.
Why should we
Yes.
go ahead looking to the fact that it was an order by agreement? Where is the question of going ahead?
Then I may be allowed to file my review, your lordship.
Then a counsel for the appellant. After attempting to argue the matter for quite some time, and counsel for the appellant has submitted that. He on instructions has submitted that he wants to withdraw this petition with liberty to file review petition before the learned single judge, dismiss with liberty as per court.
All right.
All right.
Item 14.
Well, against the same judgment, against the same judgment, I have the order, copy it, yeah. The private respondent who is performer here, he has already filed an appeal, the logical notice in that.
When the counsel for the appellant has submitted the against the impugned order, an identical appeal number 381/2000, in identical appeal
Lodge.
number the writ appeal number 381/2024. This court has already issued notices to the respondents and has also passed interim order to stop. Issue notice to the respondents returnable. Three weeks. Returnable in 4 weeks. In the meantime, effect and operation of the impugned judgment dated 27/9/2024 passed by the Learned Single Judge shall remain stayed in the shall remain stayed. Connect with writ appeal number 386/2024, 388/2024, and 381/2024.
Well, I may be allowed to serve the copy of the writ appeal to the performer respondent by hand.
Come then,
Lord.
where is the need?
The performer respondent is there, they are already before your lord.
File them a copy, they'll appear.
Yes, sir. I'll serve them.
Notices, file the requisites also. What's the problem?
Lordship. All of them.
Item 15.
By this writ appeal, I have challenged here that the impugned order dated 8/8/2024 passing WBC number 7502/2024. Before going to read the impugned order, I would like to briefing the case. The present case is related to ICDS program. This is Integrated Child Development Service Program. It was first launched in India
Yes.
This ICDS program, this is related. ICDS means Integrated Child Development Service Program. It was launched in India in way back 1975. It's basically aimed to provide nutritional meals, preschool education, primary health care, immunization, health checkup, and referral service to the children under 6 years of age and their mother. To implement this ICDS program, the Anganwadi centers were established across the country. And at present in Assam alone, 62,153 centers, Anganwadi centers is running.
Under the ICDS.
ICDS in Assam alone. Lordship, the Anganwadi centers basically is run by two persons. One is Anganwadi worker and another is Anganwadi helper. The Anganwadi helper and worker and helper were appointed by the direct recruitment. And the qualification of Anganwadi worker is SS and the helper is class SSLC. And prior to 2003, there is no provision for any promotion in this aspect. That is the promotion from helper to worker. And in 2006, Lordship, one communication was issued from the Joint Secretary to the Ministry of Women and Child Development. This notification, Lordship, kindly come to page 44. To the secretaries in charge of ICDs in all states and union territories, subject reservation of 25% post of Anganwadi workers for Anganwadi helper. Sir, madam, as you are aware, the Anganwadi worker and Anganwadi helper are the most visible grassroots functionaries at the village level under ICDS scheme. You are also aware that with a modest beginning of 33 blocks in 1975-76, The scheme has expanded gradually and presently covers 6118 blocks across the country. Recent years have witnessed not only a considerable increase in the number of ICDS projects, Anganwadi centers, but also significant efforts aimed at ensuring quality in the delivery of services and community participation. Needless to mention, the responsibilities of these grassroots workers have also increased over the years. While we have been concerned about the providing some opportunities of further growth of Anganwadi workers, it was never thought of the Anganwadi helpers in the same vein. It has therefore been felt that similar opportunities as in the case of Anganwadi workers should also be provided to Anganwadi helpers to motivate them to discharge their function more efficiently. Accordingly, a decision has been taken to reserve 25% of post of Anganwadi worker to be filled up from amongst the Anganwadi helper who have put in minimum 10 years of satisfactory service and also possess the requisite qualifications, age, education, etc., as laid down by the concerned state government, union territory administration for sanctioned Anganwadi workers. This will apply, also this is very important, in respect of all existing vacancies of Anganwadi workers and new vacancies arising out in future in the newly sanctioned Anganwadi centers. The guidelines issued by the ministry in the past that the Anganwadi workers, Anganwadi helpers should be from the same revenue village would have to be adhered to while giving effect to this new policy initiative. The states and unit territories are therefore requested to give suitable instruction to all authorities concerned with the implementation of ICDS scheme in their state's duty to strictly follow the above guidelines while selecting the Anganwadi worker. Lordship, for this communication, the state government has prepared a guideline. That guideline of page 45. This is the guideline basically for the formation from helper to workers. And Lordship, this guideline is just first paragraph I like to do. In partial modification of this department's earlier notification dated so and so, the governor of Assam is pleased to inform all concerned that the government of Assam in the social welfare department has welcomed the government decision in the right earnest and has accordingly decided to implement the decision in the same spirit with same objectives. Accordingly, this notification has been issued informing all concerned about the said decision and seeking cooperation in order to implement the decision smoothly from time to time. The government of Assam is further pleased to prescribe the guidelines to be followed strictly with which are as under. These guidelines were there. And Lordship, during the proceeding, a question arises whether these guidelines was framed in conformity with the communication that is 2006 and an affidavit filed by the commissioner of the commissioner. This is the secretary to the government of Assam, secretary to the government of Assam, Women and Child Department. He clarified that this guidelines was framed in conformity with the notification of 2006. That is 25% post can be formatted. Lordship, here in the case, in ICDS, Gauripur ICDS project, there falls 20 number of posts fall vacant due to the there are 20 number of posts of Anganwadi worker falls vacant due to the superannuation of the incumbents. 20 number of posts, and the respondents by way of 2 advertisements out of 20 vacancies advertised for formation of 17 number of posts. That is totally, Lordship, violation of the notification of 2006 as well as guideline.
Exceeding the 25% quota.
Yes.
Okay.
Violation the 2006 guidelines as well as their own guidelines. And regarding that, Lordship, I am going to read the impugned judgment. operative from 88, the finding. Para number 9 last.
Yes.
I have heard the learned counsels appearing for the parties and peruse the material available on record. The petitioner in the present proceeding has presented a challenge to the notification dated 8/7/2022 and 18/7/22 to the extent that the same has the effect of reserving all the vacant posts of Anganwadi workers available under the ICDS project for being so filled up by way of formation upgradation of Anganwadi helpers and thereby depriving the candidates like her from having their cases considered for engagement against such post by way of direct recruitment. As per the practice being followed prior to 2006, the post of Anganwadi workers were being so filled up by way of direct recruitment from amongst persons fulfilling the late eligibility criteria. The incumbents in the post of Anganwadi helper did not have an avenue for having their cases considered for future progression in their service and were required to continue to serve as Anganwadi helpers on their engagement in such capacity. Noticing such a position, the Government of India, Ministry of Women, Child Development proceeded to take a decision for providing for the Anganwadi helpers an avenue for progression in their service. The decision so arrived at was communicated to all concerned by the communication dated 6/10/2006 issued by the Joint Secretary to the Government of India, Ministry of Women, Child Development. A perusal of the communication dated 6/10/2006 issued by the Joint Secretary to the Government of India, Ministry of Women, Child Development would go to reveal that the decision so arrived at for providing an avenue progression in their services to Anganwadi helpers was to be implemented by reserving 25% post of Anganwadi workers to be so filled up from amongst the Anganwadi helpers who had put a minimum of 10 years of satisfactory service and possessed the requisite qualification as mandated for recruitment to the post of Anganwadi workers as laid down by the concerned state government, union territory administration. The said decision also mandated that the same would be so applicable to all existing, this is very important, so applicable to all existing vacancies of Anganwadi workers as well as to new vacancies arising in future in newly sanctioned Anganwadi centers. In pursuance to the said decision of the Government of India as contained in the said communication dated 6/10/2006, the Government of Assam in Social Welfare Department proceeded to implement the said decision in the same spirit and with same objectives by prescribing guidelines for the purpose by issuance of notification dated 4/3/2013. The manner of consideration in terms of the guidelines as notified by notification dated 4/3/2013 mandates that an Anganwadi helper working in a particular Anganwadi center situated in a revenue village or ward and municipality or town committee would be eligible for consideration of her case for formation upgradation against a vacant post of Anganwadi worker arising in the same Anganwadi center. She is so working and or in an Anganwadi center situated within the same very revenue village or ward of a municipality or town committee wherein the Anganwadi center where she is so engaged is so situated. The notification dated 4/3/2013 having laid down the manner in which the formation upgradation of Anganwadi helpers to be so affected, it is to be seen as to how the quota for formation of the upgradation and direct recruitment against the post of Anganwadi worker is to be maintained. As per the procedure put in a place for recruitment against the post of Anganwadi workers, 75% post to be filled up by direct recruitment and 25% post to be filled up by way of formation of the upgradation. The said position was clarified in the hearing by Mr. D. Nath, learned senior government advocate, by referring to the affidavit filed by the Secretary to the Government of Assam, Women and Child Development Department, by stating that the ratio of direct recruitment to the promotion in respect of post of Anganwadi worker in the ratio of 75%, 25% would be.
We have gone through the judgment. So now what's wrong in this judgment?
Yes, Lordship, the calculation is that they calculated the 25% in total number of centers, not in existing vacancies.
But sir, this 400 centers are.
Yes, that does not mean there is a 400 vacancies, existing vacancies.
So,
Only 25% is permitted to promotion.
so 400 centers are there, so 100% vacancies can be filled by promotion.
100%, yes, posts can
100,
be.
100
But
posts.
at the same time, existing vacancies, Lordship. The guidelines says in the existing vacancies.
This 4/3/2013 says only this, and you have not challenged this 4/3/2000.
No, Lordship, no. I am not 4/3. 4/3 does not say, Lordship. That is why a confirmation was asked from the secretary.
How many posts were available there?
Post, Lordship, there are 400 posts admitted position by the.
400 posts were there.
Yes,
And out of them, 100 posts can be reserved
yes,
for the promotion and so and so.
yes.
So all the 400 posts are vacant.
No. Lordship, it is running for decades. They are decades, Lordship, somewhere get appointed, their Lordship.
Notice. Returnable. 6 weeks, just the AD. We hear them then.
Item 16.
May I please, your lordship?
Similar matters.
Yes,
notices
my lord.
Have been issued.
No, my lord. Today's motion.
Some similar matters. have
Yes,
been-
my lord.
notices Have been issued.
Yes, similar matter passed by your honor.
There are 2, 3 matters today.
No notification.
Challenge to the provisions of the Act of 2017 was taken up by the special bench and have been disposed of, madam.
Yeah.
And so far as the sections that provisions that he is challenging, those provisions were not touched by the special bench, save and except to the extent that tutors instead of a fixed pay,
Can get
perhaps be entitled to a scale, which can be fixed by the government even if
And
it
they
was
are
the minimum.
challenging this validity of the rule which provides that.
They should have a fixed pay. And they also say that they should not have been provincialized as tutors, they should have come in as teachers. Because when they were initially appointed at the first stage, they had the qualifications required.
This is not covered by this.
Oh, everything is covered.
Not covered by this.
Covered.
division.
Covered is what I'm saying.
So now what do you want? When it is already ordered, then why you have filed this fresh petition?
No, my lord, I want the similar order. my
They
lord.
did not approach then. Once the
Yes,
judgment has come, they are starting to approach all the persons who were left out.
Judgment in red, but it is not.
Yes, my lord.
Now they are.
Maybe
approaching-
covered by that judgment, my lord.
Covered by that judgment, then why you have filed this fresh petition when the judgment is already
Actually,
there?
we have filed earlier, but it could not be checked with that series.
You have filed earlier.
Yes, my lord. Could not be checked due to some personal.
I think so there are 2, 3 matters, other matters are also.
Yes, my lord. Item 19 and 20.
19 and 20.
Yes, sir. Similar, my lord.
When a concept of the parties are in agreement that the controversy involved in this petition is squarely covered by the decision rendered by this court on 2024.
4/10/2024.
Writ petition number 2729/2019 and another connected writ petitions.
Some other petition passed by this honorable court?
Connected writ petitions.
No, my lords.
In that bunch of
Yes,
writ
yes,
petitions
yes.
were there.
Yes.
These judgment, division bench judgment, by this judgment, bunch of writ petitions have been decided.
Yes.
Yes, my lord.
Disposed of in terms of and other matters are
Same, my lord. Similar, my lord.
which one?
19 and 20.
19 and 20.
19 and 20.
Yes, my lord.
Okay. Same order.
Item 17.
May I please your lordships?
Have you ever filed any complaint with the police?
Yes, yes,
What
lordship.
is that?
Police lordship, we have approached.
Police under the CRPC, have you ever filed any complaint?
Lordship, the lordship has, if lordship has seen lordship,
Police
Assam police,
complaint, have you ever filed police complaint? Essentially.
no lordship, till now we have not filed any police complaint.
Essentially, you are claiming that there are certain, they are misappropriating the, whatever the things or the items meant for distribution of the, under the PDS system. You should have filed and you're seeking a inquiry by the CBI.
Any agency
Any
lordship,
agency that why you have not- Whether you have filed any complaint with the police and the police has not taken any cognizance of that.
actually
That-
Assam police, lordship, if I may submit lordship. Lordship may see at page number 66, lordship, Assam police had already, they had arrested one oil tanker, lordship.
Sir, even though if you are pointing out some specific instances, approach the police. Ultimately, it's a criminal case.
Lordship,
To approach the police, file a complaint under the CRPC, there is a procedure. Earlier, there was 156. Now the new BNS is a similar provision.
lordship.
Challenge that. Sir.
Lordship, we can do that, lordship, but lordship may kindly appreciate lordship, we have already approached the chief secretary, the high end.
How the chief,
The higher-
they are not supposed to register a
Lordship.
case and inquire into this, whatever the allegations you have leveled. Ultimately, this is you mean to say that we, in fact, we conduct an inquiry.
No, lordship, I'm not saying that,
Yes,
lordship.
it seems, sir. We conduct an inquiry on our own and then we'll pass an order. Okay, what is the jurisdiction of this court doing that?
Lordship, in
Or
that case.
Setting up a criminal process in motion, you have to follow the procedure laid down under the law.
No, no. Lordship, in that case, lordship, we may be allowed to withdraw this PIL. We will file a complaint with the concerned police authorities, and if no action is taken, then we will.
Concerned police authority or the concerned courts can very well move and complain.
Lordship,
It's known as istigasa in the, that you can move and
lordship.
why this PIL? The petitioner has raised issue regarding the issue regarding the illegal committed by the individuals in distributing by the individuals in misappropriating the kerosene. In fact, you have raised this regarding kerosene only.
Lordship, kerosene and other petroleum products, lordship.
The kerosene and other petroleum products supposed to be distributed to the public at large in the PDS system, public distribution system, in the state of Arunachal
Pradesh.
in the state of Arunachal Pradesh. Full stop. It is contended by the petitioner that certain individuals in connivance with the government functionaries are indulged in misappropriating the items supposed to be distributed under the public distribution system. It is contended that though in some of the cases, the police has registered the criminal cases, but in the instances pointed out by the petitioner by the representation to the chief secretary of the government of Arunachal and other officials of the government of Arunachal, no action has been taken against them. Full stop. Having heard the learned concept of the petitioner and after going through the material available on record, prima facie we are of the view that the petitioner has contended that by interfering with the public distribution system, the system, certain individuals has committed some criminal acts which are required to be thoroughly investigated. Stop. On a pointed query, learned counsel for the petitioner has frankly admitted that the petitioner has not filed any complaint with the competent police station or to the competent criminal court regarding the criminal activities carried out by certain individuals. Stop. At this stage, the counsel for the petitioner on instructions has submitted that he may be allowed to withdraw this bail petition with liberty to approach the concerned police station or the concerned criminal court for the concerned court highlighting the criminal activities carried out by the individuals resulted in misappropriation of money as well as siphoning of the items supposed to be distributed to the public at large under the public distribution system. Dismissed with liberty as prayed for.
I'm obliged, Lordship.
Item 18.
May it please your lordship. In this matter, I am aggrieved by the non-consideration for promotion, my lord. I'm a retired district judge. My lord,
Once you have already typed of the name of the person who is going to be supposed, how can we grant a relief?
my lord, here the other thing is, my lord, the
The thing
non-consideration.
is, ultimately you are seeking promotion against a person who has already been promoted.
My
You have not made him a party.
my lord, initially he was made, my lord, but
Then why you are striking off, striked off?
there was a subsequent development, my lord.
You are,
My lord,
both officers can't be promoted on one post even
My
though
lord.
if we find
My
that
lord.
you have a case for, genuine case for that. What's wrong in that? Like after 3 years, you have approached the court.
No, my lord, not exactly 3 years. It was after the impugned order was of 1/9/2017, my lord. I had applied for information under the RTI, my lord. That was not granted the entire information.
Ultimately, what's the Leonard Singh that just said that you have struck off the name of the person against whom you are seeking
My lord.
this, against whom the post or which is occupying you are seeking, then how can we grant this relief?
My lord, it was only for the financial benefit, my lord, because I have already retired.
Without there being any order
My lord,
to remove that, remove the name of that from the relation list and including your name,
My-
how can that relief can be
My lord,
granted?
my lord, initially he was made a respondent, my lord.
Admit. So and so, put an appearance on behalf of the. All the respondents are. They may file their counter to the writ petition if desired, so list in due course.
My deeply obliged.
Not much.
Item 23.
We have issued two orders by which petitioners, we have issued two orders, my lord.
Where is that?
Yes, my lord. Petitioner has been promoted, the promotion has been restored and now he has been again, they are posted also, my lord.
They are,
Posted in the promotional post, my lord. So I think, my lord, nothing survives in the reader.
Correct, he's so fair. 7 of us were there. Unfortunately, one could not be because he was under suspension, subsequently reinstated. I'm told in under process. Rest all promoted and posted.
So nothing remains, my lord, and we are at liberty to proceed as. Of
course.
With the notice.
I can foresee what is coming, of course.
what is that earlier order?
My lord, earlier order, my lord, finds at page 43, my lord. The first order of the honorable single court. Page 43, my lord. Cancellation of promotion was set aside on the ground of violation of national justice. Paragraph 9 and 10, my lord, page 48.
What is that order?
It is not a-
When it comes to the. Respondent has submitted that. The respondents have. Restored. The promotion granted to the
Petitioner, appellants.
appellants. Wide order dated. 31/8/2024. Pursuant to the direction given by. Learned single judge in writ petition number
5299 of 2022.
5299.
Of 2022,
5299 oblique 2022.
22. Order dated
Wide impugned order, wide order dated.
1/2/2020.
Wide order dated 1/2/2024. Stop. Then council has submitted that. Since the order dated 1/2/2024 passed by the learned single judge in writ petition number 5299 of 2022 has complied with. Now, as per the said order, the respondents are free to proceed further. The respondents are free to issue notice.
Notices issued,
What is already issued?
already issued.
Again, issue a fresh notice.
Notice at page 42,
Very good.
12/10/2020. That was challenged in the second writ petition.
Now the respondents are free to proceed.
Page 52, my lord.
Free to proceed further. In respect of the show cause notices issued to the appellants dated 12th of February 2024. It's from. In the learned counsel for the appellant is not in position to disprove the said fact. In such circumstances, this writ appeal is disposed of while maintaining that is disposed of with liberty to the respondents to proceed further in respect of the notices, show cause notices issued to the appellants dated 12/2/2024
If I may just
Briefly,
add on, my lord, for the correction of records.
and conclude the said proceedings expeditiously within a period of 1 month. After providing opportunity of hearing in accordance with law, in accordance with.
Just to add on, my lord, so far as appellant number 5 is concerned, his promotion has not been restored. Unfortunately, he was suspended, reinstated. I'm told it's underway. So not all the
I'll
appellants,
look into it.
appellant number
I'll-
5 has not been
I'll
restored.
instruct my.
Just
client.
It's okay, just to inform correctly. my lord.
In between the respondent number name, the concept of the respondent has submitted that. Schedule with that. Schedule with that. Granted to the appellants number 1 to 4,
1 to 4, 6 and 7.
1 to 4, 6 and 7.
6 and 7.
Again, 1 to 4, 6 and 7. इसमें लिख देना एक पेन लाइन जो it is submitted that in respect of appellant number 5, the order could not be issued as he was under suspension. But now he has been reinstated, so the consequential order would be passed very soon.
I'm grateful for that.
For hearing, item 25 to 42.
Order dated 28/10/2024 in the consequential promotional order dated 4th of October 2024 are taken on record. Taken.
May I please, Lordship? Lordship, I am appearing in item number 25, Lordship.
25.
25.
What about the others?
Lordship here, is.
I am in, paying for item number 41, but
41.
I mean, 26 to 28. 26, 27, 20.
And remaining item? So all the appellants are represented through advocates today.
Lordship, my case is separate Lordship. It relates to the sixth schedule area of Dima Hasao district Lordship. Their service condition is something.
These are not same.
No,
Not same.
Lordship, the issue is the same. They're all
It
teachers,
said,
Lordship.
Lordship, it was categorized in six
Lordship,
parts, Lordship.
They are all part, it has been reflected in one common judgment, Lordship. It was heard all together. There are different categories of teachers, Lordship. But Lordship will have a better understanding if all the petitioners are heard in one go, because if it is heard separately, Lordship, then there will be a, so if all the
But Lordship,
appellants.
in my case, there is urgency, Lordship. They retired from service during 2016 to
Yes, Lordship.
2020.
But if we have to hear all these matters together, then certainly we have to hear these matters at once.
Yes, Lordship.
We can't bifurcate all these things, like, we can't hear separately.
Lordship, my service condition is something different, Lordship, because
Lordship,
it
it
is
has
a
been addressed in the same judgment, Lordship. Everybody's, there has to be a certain.
We are reviewing this order of the learned single judge. We can't review it in piecemeal, man.
order is separate order, Lordship, common order, Lordship.
no,
In a categorized
We have to
category
hear
wise,
it,
Lordship.
all the persons together, all the advocates. You make a consensus in between you, which date is available to you, all the advocates may come and we hear all these things.
Lordship, it is. Others are not present, Lordship, it is.
Then what? Please try to understand
Lordship.
our predicament.
Lordship.
We can't hear in the piecemeal that writ revision, this writ appeal is so, and half of the order is there and another order is there. We have to hear all those together.
Yes.
January, may we make a consensus and then we'll hear this matter. In the month of January.
Also, December, Lordship, short date maybe.
December,
Lordship.
Recommendations are
names
there,
have been applied.
recommendations are there and everything, we'll hear you in January.
Lordship, let them decide a date on January altogether, Lordship.
8th of January again, then
Let them decide, Lordship. Let the petitioner decide. Because they have to make a call.
Yes, Lordship.
the,
The others are not appearing.
in the, this week commencing from 20th of January, whatever the date.
Lordship.
And please make an endeavor that all the advocates should remain present. Oh,
Yes, sir.
that is the matter.
Lordship. Yeah.